हेलो एवरीवन, वेलकम टू लीगल ब्लूप्रिंट। मैं हूं साक्षी और आज की इस वीडियो में वी विल डिस्कस द लॉ ऑन कॉन्ट्रैक्ट बाय माइनर। सो फर्स्ट वील सी what is the legal validity of such a contract entered into by a minor. Then we'll discuss that in case the minor represented himself or herself to be a major, in those cases, can estoppel be ordered against such a minor to deny the fact of his or her minority. And lastly, we will discuss that if the minor received any sort of benefit in that contract, can court order to return that benefit to the person concerned, which is known as order of restitution. So let's begin.
Indian Contract Act का Section 2H defines contract to be such an agreement that is enforceable by law. That means two essential elements are required to make a contract: agreement and enforceability by law. It is Section 10 of the Act that talks about enforceability, and one of the conditions therein is that the party should be competent to contract. Now, who are competent to contract? According to Section 11, any person who is of age of majority as per the law that applies on them is competent. And in India, it is Indian Majority Act 1875, which is the general law on the subject. Iska Section 3 says that every person domiciled in India shall attain majority on completion of 18 years. इसका मतलब ये हुआ that any person under 18 years of age are incompetent to enter into a valid contract. अब अगर minor का contract is not valid, then what else can it be? Let us discuss two other kinds of contract in the act. First is avoidable contract. These are those agreements that are enforceable only at the option of one party. Hence, if that party chooses not to, that contract becomes void. Other is a void contract. This is an agreement which ceases to be enforceable by law. It is usually by a subsequent event that contract becomes void and hence cannot be enforced there. Now, what is the status of a contract if entered into by a minor? This question has been left unanswered by the Indian Contract Act, and this void was filled by the landmark judgment of Mohri Bibi versus Dharmodas Ghosh. Let us look at facts once to understand. So there was Dharmodas Ghosh, who is minor in this case, and Pramod Dutt, who was a moneylender and also Mohri Bibi's deceased husband. Dharmodas Ghosh ने एक लोन लिया from Pramod Dutt and in favor mortgaged some of his property to him. However, here Pramod Dutt already knew about Dharmodas's minority, and even then he entered into a contract with him. In light of these facts, court ने यहाँ दो issues बनाए. First, whether the contract by the parties is void or voidable, and second, whether the defendant, that is minor, liable to return the amount of loan जो उसे इस contract में receive हुआ. Moving on to the first issue, that is the status of a minor's contract, कोर्ट ने पूरे लॉ को एनालाइज करने के बाद रूल किया that a minor being incompetent to contract, a contract by a minor is in violations of Section 10 and 11 of the Indian Contract Act, and hence such a contract will be void ab initio. This is a Latin term which means void since inception. इसका मतलब ये हुआ that such contracts will have no existence since the beginning and it will only be an agreement with no legal incidence. This settled the position of our first question that a contract by minor is void ab initio. It is a very important term which is not used anywhere in the Contract Act. Now, what do you think is the objective of this law? So here it is important to understand that law considers minor to be incapable of having sufficient understanding. इसीलिए कोर्ट ने भी लॉ को ऐसे इंटरप्रेट किया so that a protection can be afforded in favor of minor and hence minor को protect किया जा सके from any kind of exploitation. But ये जो general principle मोहरी बीबी के decision ने establish किया, this is subject to certain exceptions जिन केसेस में अ कॉन्ट्रैक्ट इज एंटर्ड इनटू बाय अ माइनर बट फॉर हिज बेनिफिट. These are cases of contracts of necessities, apprenticeship contract, contract of marriage, minor as a partner and also as an agent. Because in cases में it is for benefit of minor, even a minor can approach the court and enforce these. इस केस का दूसरा इश्यू था, is minor liable to return the loan amount received by him? So money lender ने आर्ग्यू किया फॉर रेस्टिट्यूशन ऑन द बेसिस ऑफ सेक्शन 64 एंड 65 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट, जो बात करते हैं रेस्टिट्यूशन इन केस ऑफ वॉइड एंड वॉइडेबल कॉन्ट्रैक्ट्स, एंड ऑन द बेसिस ऑफ सेक्शन 41 ऑफ स्पेसिफिक रिलीफ एक्ट विच टॉक्स अबाउट रेस्टिट्यूशन इन केस ऑफ कैंसिलेशन ऑफ एन इंस्ट्रूमेंट. सो कोर्ट ने इस रिलीफ को डिक्लाइन करते हुए कहा that section 64 and 65 of Contract Act presupposes existence of some contract, but because minor's contract is no contract, this cannot be ruled. And section 41 of Specific Relief Act confer करते हैं discretion on court to rule for restitution. But because in this case money lender को already पता था about धर्मोदास घोष's minority, कोर्ट ने कोई बेनिफिट रिटर्न करने से मना कर दिया. नेक्स्ट कम्स द क्वेश्चन ऑफ कैन एस्टॉपल ऑपरेट अगेंस्ट अ माइनर. सो एस्टॉपल एक ऐसा लॉ है दैट प्रिवेंट्स एनी पर्सन फ्रॉम डिनाइंग देयर प्रीवियस स्टैंड, बट दिस डॉक्ट्रिन डज नॉट ऑपरेट अगेंस्ट अ स्टैट्यूटरी लॉ, एंड मोरी बीबी के डिसीजन ने ये क्लैरिफाई किया कि माइनर का कॉन्ट्रैक्ट इज वॉइड एब इनिशियो. इस रीजनिंग के बेसिस पे वी कैन से दैट अ माइनर cannot be estopped from denying the fact of his minority, even if he misrepresented himself to be a major and hence competent for contract. Now comes the last question of restitution against minor. Let us look at first the English doctrine of restitution. The famous case on this is Leslie versus Shield. इस केस में कोर्ट ने कहा that restitution is possible only if property is traceable and in possession of minor. अगर प्रॉपर्टी माइनर के पोजेशन में है सिर्फ तभी रेस्टिट्यूशन ऑर्डर किया जा सकता है, बट नो रेस्टिट्यूशन कैन बी अवॉर्डेड इफ प्रॉपर्टी हैज़ बीन कन्वर्टेड. दैट मीन्स या तो उसको बेच दिया गया है और किसी और फॉर्म में कन्वर्ट कर लिया गया है, और कैश वॉज द बेनिफिट ऑब्टेन्ड. बिकॉज इन दीज केसेस अगर रेस्टिट्यूशन ऑर्डर किया गया, that will be like enforcing the contract, which cannot be done. Now moving on to Indian position on this topic, the landmark case is Ajudhya Prasad versus Chandan Lal. इस केस ने इस पोजीशन को establish किया, which is followed even till date. कोर्ट ने bifurcate किया अपने आंसर को in two parts. In situations where minor appears in front of court as plaintiff asking for some relief, and in cases where minor is a defendant defending the case filed against him or her. So where minor is a plaintiff, court ruled that restoration of benefits can be done as received. But in case where minor is a defendant, restoration can be ordered only to the extent that the estate of minor is benefited. And here benefit means any benefit of a permanent nature.
Now that we have studied all the law on contract by minor, let's quickly revise it once. So a contract by minor is void ab initio, and even if minor misrepresents himself or herself to be a major, no estoppel can be operated against a minor to deny their minority. And lastly, the fact that can court order restitution against a minor depends on whether the minor is standing in front of the court as plaintiff or as defendant. So this was all you need to know about law on contract by minor. In case we have forgotten something, don't forget to comment it down below. And if you like the video, do not forget to like, share and subscribe to the channel for more such content. Thank you.